Lindblom in. Stand there on the step, and then when Lindblom comes in, step in front of your judge.
What here?
No, over there. Stand there. You go.
Right there.
Yeah, and then when Lindblom walks past, you step here.
Of Barton Park Estates Ltd and the Secretary of State for Housing, Communities and Local Government.
Yes, Mr. Fraser-Ricketts.
If it please your lordships. My lords, in this matter I appear for the appellant Barton Park Estates Ltd, who also the claimant in the matter below. Then from Mr. Parkinson appears for the first respondent, Secretary of State, and then from Mr. Reader for the second respondent, Dartmoor National Park Authority. Yes. Can I first of all start by thanking the court for its consideration on the last occasion this matter came before us.
Well,
the situation
we all hope, of course, that your recovery was swift, but it was clear that we couldn't continue on the last occasion.
No, I'm very grateful for that. Appreciate
the
inconvenience it caused.
Fortunate that we could reconvene with the same constitution within a reasonably short time. This was the first available date for that.
We were almost appreciative on this side of the room, and I can assure the court.
Well, that's kind of you to say so. Thank you.
Ensured last night that the firstborn son of the chef tasted my food before I did.
Yes. Well, now, just to help you, before you get going, we've of course read the papers, so we're familiar with everything that's been submitted to the court. That includes, of course, the skeleton arguments. So please assume that when you're making your submissions, all of you. The second thing to say is that we're grateful for the focus that was given to allocating time between yourselves yesterday. We don't know exactly how you decided, I think, to divide it up, but this case is a one-day case, and we're going to finish today. So can you indicate what at least the broad split of time
I don't think there was ever a split of time as such, merely a consensus that we would finish within the day.
All right.
Given your lordship's indication about the state of the papers, I mean, I would anticipate that would probably be done within an hour and a half.
Oh, I see.
That's dependent
on
interventions.
All right, yes, no, we will, of course, be asking questions.
Of course.
But, that's very helpful to know.
So I'm comfortable that we should finish today without need for formal imposition of time.
All right, well, fine. Thank you.
Well, my lords, the broad outline of this case is as follows. The appellant sought a certificate of lawfulness for the use of the site for up to 80 caravans in permanent residential use. And I note that simply to make the initial observation that the granting of a certificate merely certifies that some development or some action is lawful. It does not preclude or prohibit any other lawful activity on a site. It's a purely permissive document. And in the circumstances where there is an extant planning permission, as in this case, there is in effect a two-part exercise required when considering whether to grant a certificate of lawfulness. The first part is to consider whether the proposed use falls within the scope of the existing planning permission. And if it does, that is an end of the matter and the certificate ought to follow. If it is not within the scope of the existing permitted use, then one has to inquire whether there is a material change of use. If there is a change of use but it is not material, then again the certificate follows. It's only if there is both a change of use and that change of use is material that the certificate is properly denied. And that's the essential framework of this case.
Yes.
So, my Lord, taking your Lordship's indication that the court's familiar with the papers, I'll go, if I may.
I should have said as well, though it will be understood, I'm sure, that we're grateful to you for having supplied the, to the best of your ability to do so, the plans and maps which demonstrate the extent of the site for the 2013 permission,
Yes.
and helped us to understand its relationship to the 1987 site.
Yes.
That was a helpful exercise, and we've taken that on board as well.
I'm glad. I mean, for the purposes of my submissions, I'm not really going to touch on the 2013.
No, you're focusing on the
permission.
1987
On the
planning.
1987 permission, because those aspects of the 1987 permission, which were altered by the 2013 permission, don't in any event change the essential logic which we rely upon to establish the lawfulness of our activity.
No, I think we'd expected that.
Yes. So, my Lord, the 1987 permission is found within the supplementary bundle, as it's been described at page 3.
Yes, thank you. Yes.
And the one of the slight oddities of this case is that what everyone has taken as being as well the root permission, the key permission, clearly developed from a situation where there was already activity and already acceptance of the form of use on the site, because the description of development is for a proposed site enhancement involving an amendment of existing provision at the site to allow for 9 residential vans, 16 holiday chalets, 18 static vans and 30 touring units. As your Lordships will see. Now that was taken as establishing, in the sense of being the marker, perhaps as one might put it, for the fact that there was an existing lawful caravan site use, and the term enhancement, although slightly baffling in the context of the papers we have before us, is nevertheless taken as meaning permission for, and that's the way the inspector and the judge below approached the matter.
Yes.
But what one immediately notes about this permission, for the purposes of my submissions, is that it does not contain any conditions which limit the number of caravans which may be stationed on the site. It does not contain any limit on the type of caravans or a limit of the tenure of the caravans. One sees many provisions of this sort which, for example, contain a condition limiting caravans to holiday use only between specified dates and so forth. And this permission, which in its words of description includes both residential vans, chalets which are explicitly identified as being for holiday use, and then static vans and touring units which do not have any descriptions to the type of occupation they're put to.
Would you accept that reading 18 static vans in the permission with condition E, referring to static holiday caravans, reading those together, it's clear that the 18 static vans are to be holiday caravans?
That is clearly the most appropriate reading, but that doesn't matter for the purposes of my submissions. The question that the court has to wrestle with is, given the principles in the I'm your man line of authority, which I'm going to come to, what is actually permitted by this permission and what is limited by effective condition by this permission.
Now, I follow all of that, I think, but I just simply construing the permission, we can read the 18 static vans as referring to holiday vans. You accept that, I think, before we get on to I'm your man and so on.
Well, the permission refers to 18 static vans, the condition to static holiday caravans. I mean, there's a fairly obvious link up between those two.
Exactly, that's what I'm asking you,
Yes.
and I think your answer is yes.
Yes, I think my answer is yes. Well, forgive me.
I would put it perhaps in this way, which is not in any way different, I think, from what my lord has asked you. One can see, can one not, that the condition E, I'll put it this way, maps onto or corresponds to the description of development, at least in identifying three kinds of things, if I can put it like that: chalets, which presumably are the holiday chalets, static holiday caravans. There the word holiday appears not in the description of development but in the condition. This was my lord's point.
Correct.
And then the pictures for touring units, and that clearly relates back to the 30 touring units. So there's an interconnection, is there, between the condition and the description of development?
There is, but in my submission, not enough to overcome the fact that, first of all, there's no limit on the number of caravans in any particular characteristic, in any particular category. And forgive me, if I just make this point before I take Lordship's question, and also that the description of development explicitly includes residential units, residential vans, with a number to be sure, but not a number which is enforced by condition. And that's the significant point in my submission. Lord.
Even in the wording of the description, not the conditions, there's a distinction drawn between 9 residential vans and 18 static vans. So if those static vans were meant to be residential, you would need to have that. You'd have 27 residential vans. So the static vans, even before you get to the conditions, must have been something intended to be different from residential vans.
Well, clearly that's the way the condition reads.
Not the condition.
Forgive me, the description of development.
Yeah, the description is the point.
Yes, absolutely. But the...
So you know from the wording that it's different, and if you and you could guess at it, but if you had any doubt, the condition fills it out.
Yes, in the sense that it draws that distinction in the description of development.
Yeah.
But what the condition does not do
No, I understand
is
that.
to impose a limit. And that is a point of central importance for my submissions. And we'll come back, if I may, to that point in the context, in the way in which the judge below sought to, as it were, dismiss the effect of the I'm your man principle. So that's the planning permission, and I've drawn attention to various features of it, and Lordships have indicated some other features.
Do we need to look at the reason for the condition as well? To protect the character, it's on the next page.
Yes.
To protect the character of this part of the Dartmoor National Park during the winter months.
Yes.
What does that signify?
Well, what it signifies is what was the possible intention of the National Park Authority in imposing that condition. again, what it does not do when one properly construes condition E is to give condition E more meaning than its words can properly bear. Because, I mean, effectively, and this in my submission is the area that the judge fell into, and we'll look at this in a little more detail later, but the judge allowed the reason for the condition to drive an interpretation of the condition which it could not on its words bear. One can't allow the reason for the condition to override the plain words of the condition. And as I'll come back to submit in a moment, those plain words of the condition are not effective to prevent or to render unlawful a residential occupation of the site pursuant to that part of the permission which permits residential use, residential occupation of caravans, in circumstances where there isn't effective control by condition.
Yeah, I mean, the central point in this submission is, perhaps even in the appeal itself, is that there is no condition limit on the number of residential caravans.
Correct. Correct.
Just following up my Lord's point about the way in which condition E tracks the language of the permission.
Yes.
Suppose condition E had said the 16 chalets, 18 static holiday caravans and 30 pitches for touring units shall only be occupied between those dates. Would that be a condition as to numbers?
No, I don't believe it would. It would simply say if you had those numbers, then those numbers would be, or the caravans that fell within those numbers would be subjected to those particular conditions. What would, in my submission, what would need to be there is a condition explicitly limiting the numbers of caravans that could be on the site, or at a push, the number of caravans of a particular type which could be on the site.
Yeah. Okay, thank you.
And then the reasons for conditions, I know it's conditions, not the description, but reason F is to ensure that part of the site remains available for use by touring caravans. Does that indicate that whoever was writing this document as a whole thought that at least part of it would be for non-permanent vans or non-permanent use?
I'm sure that was the case, my lord, yes.
But he didn't achieve it.
But they didn't achieve it.
Okay.
The important thing with conditions, obviously, as your lordship should appreciate, is one has to look at their wording rather than trying to define the subjective intention of those who wrote them.
But can you use F to try and work out what was meant by drawing a distinction between residential vans, chalets, static vans and touring units, to say, well, some of those are clearly going to be residential, but some of them are going to be touring, that he anticipated that that permission meant and was to be interpreted as covering and involving both types of use, not either or exclusively.
Well, the first thing to say is that one needs to be careful about the language and the distinctions of language, in the sense that a touring caravan merely describes a particular type of caravan, i.e. one effectively that's easy to hitch up to the tow bar of a car and drive off with. It does not preclude the use of that touring caravan for permanent residential use. Perfectly possible to have a touring caravan which, whilst maintaining all the physical features of a touring caravan, is lived in year round.
Normally, when a court is construing a document, whether it's a contract or a piece of legislation, the idea and trying to find out what it allows and what it prohibits, the idea is to read the document as a whole. But you're saying, I think, that in the particular, maybe unique context of planning permissions, that rule doesn't apply. You simply got to focus exclusively on what there is under the heading of condition. Is that have I understood that correctly?
No, not quite, my lord.
No.
And I think there's authority to support the proposition that one, in construing a planning permission, one looks at the whole document, including the conditions and the reasons given for them.
Yes.
Well, that's what I would have expected. But if it's clear from that that something is not permitted or is prohibited, why does it matter? I mean, maybe the cases say it does, but why should it matter whether something is specifically prohibited under condition if it is clear from the document as a whole that it was not intended to be permitted and was intended to be prohibited?
Well, perhaps I can go to the line of authorities, which I would rely on to develop this.
Do you want us to put the planning permission away for now? Or
It's
we're going to come back to it,
I suspect, given the nature of the questions coming, that it's probably as well to have it.
I mean, it's
to hand.
It's the central document in the case.
Yes, it is indeed the central document in the case.
Yeah.
But the line of authority, and it's a well-established line of authority, and a line of authority which was referred to as regarded as settled law in the Lambeth case, is the line of cases coming out of I'm Your Man, which is tab 18 in the authorities bundle.
Well, two points about that. Firstly, I've got a number of
No
authorities
tabs.
bundle, and I've got no tabs, and I don't even have an index which tells me what the tab would have been. So you're going to have to give a page number.
Right.
I think it's 167.
I have it in mind as 165. I know that a further authorities, well, I assume it's a further authorities bundle, came to your Lord's.
Well, I've had two authorities bundles in the course of preparing the case. One came yesterday.
Yes.
I'm Your Man is on page 166 of the black folder that I've got. But I don't. But like my lord, I don't have tabs.
Right.
So it's I think it's 166.
It was 165 in the first version.
It's only 165. Well, I'm assuming it was 165 in the first version.
We were not told what the differences were between the first and the second versions, which is not as helpful as it might have been.
No. I was told yesterday that the only difference was that the passages which it was intended your lordship should particularly focus on were marked in red on that new version. But it appears there are some discrepancies in page numbers. Albeit hopefully they're narrow enough.
Speaking only for myself, I didn't do the exercise, and I didn't feel obliged to do the exercise of comparing two bundles of authorities with each other, having had the other one some weeks ago. So let's do the best we can with what we've got.
Yes, and I confess, my lord, I'm in the same position as you are.
Yeah.
Having marked up the last set.
Yeah, there it is. 166 or 165. I'm Your Man.
I'm Your Man. And Lord, this is a case where planning permission was applied for and granted for a temporary, or what was described in the description of development as a planning permission for 7 years. And there was no condition to that effect on the planning permission, but the words were clearly stated in the description of development. And effectively the point was established in that case that in the absence of a condition imposing that time limit, the mere suggestion or the mere writing down in the time limit, in the description of the development of the time limit, was insufficient to make that time limit effective. And the reasoning picks up at the bottom of what I have as 171.
Yeah.
Again, unfortunately, this particular law report doesn't have paragraph numbers attached. So
this is in the planning law reports, or is it the Estates Gazette law report?
this has been taken from the Estates Gazette.
Yeah. It's never been reported in the law reports as such.
It appears from the annotations that it's at least been reported in the.
Yeah. Never mind. Don't worry. Page 171.
At the very bottom of my 171, I put it that way.
Yeah.
There's the simple word decision.
There are internal page numbers at the top right-hand corner, if that helps. There's page 7 of that, if you've got
Thank
those.
you, my lord. Talk about the
Yeah. No, well, that's actually 172 in yesterday's bundle.
Yes.
Yes. Yes, at the very bottom of page 7 of the internal
Yeah.
pagination
Decision. Yes.
is the decision, and the effectively the two questions there: power be implied to impose limitations on permission granted otherwise than by development order. What is the effect of a use permitted on an application expressed to be for a limited period? And then, I mean, to skim through to middle of page 9.
Yeah. Yes.
Accepting the submission that because of the absence of the condition, submission that the 1995 Commission permitted change of use of the appeal buildings and did not impose any limit on the period. And that use would be subject to enforcement under the Act. And then the next authority, which I have at page 177.
Yes. Alton Kynack.
Alton Kynack, yes.
Yeah.
And if one picks it up at paragraph 25.
Yeah.
Paragraph 25 there, one sees first of all a summary of the decision in I'm Your Man, as we've just touched upon. And then at paragraph 39, sets out the heart of the matter.
Yeah.
No basis for distinguishing I'm Your Man. That case was concerned with a temporal limitation, whereas in this case the words are as an extension to premises at number 15. Relevant principle is a general one. If a limitation is to be imposed on a permission granted pursuant to an application, it has to be done by condition.
No.
Now that's, in my submission, is a well understood principle. And as I said, it was regarded by Lord Carnworth and Lambeth as being simply part of the general law now.
Do you want to look at Lambeth?
Forgive me as a novice in this area.
Yes.
Drawn from the wording of the statute, which very basic question, which wording in which statute?
The Town and Country Planning Act gives permission to, gives the statutory power for applications for planning permission to be made. Sets out a requirement that there be planning permission if development occurs.
Yes, of course.
Granted by a number of routes, including by express application.
If I can help you,
Sorry.
I think this is the answer to my Lord's question. Section 72, subsection 2 of the Town and Country Planning Act 1990 is the answer to my Lord's question, I think.
Yes, thank you very much.
I think that's right.
I'm sure your lordship is right.
It's referred to in paragraph 25 of Lord Justice Richard's judgment in Alton Kynak.
Yes. Right, yes, thank you. Thank you very much.
But sorry, I simply doing my best to assist you. I didn't want to cut off your answer to my Lord.
No. I mean, if I'm conscious that my lord is obviously very experienced in these matters of planning law. My Lord Justice Mel,
Isn't.
well, I wouldn't say that, but
it's true.
comes from a different perspective.
No,
But I mean,
I've seen it now.
That's, I think, the provenance of the words, the expression drawn from the wording of the statute.
Yes.
Yes, no, I'm very grateful.
The other case I was wondering whether you were going to come to at some point, whether before or after Lambert, is Winchester.
Yes, I am going to come to
So
Winchester.
take your own course, obviously.
I don't really intend to dwell on Lambeth, not least because I think it's not included in the bundle of authorities, unless I'm mistaken.
You may well be right.
I think I was trying to be clever when I advised on putting together this bundle, because it's in the
Well, it's commendable, of course,
ICLR Book of Authorities.
to keep the
which I'm now
authorities
omitted to bring to court.
to a reasonable minimum. I haven't actually added up the number of cases that are included, but one that isn't, I think, is Lambeth in the Supreme Court.
Yes, I fear that's correct. Can I perhaps park that and ask your lordships to take it on trust from me that it is referred to in those terms, and I'll get the reference and
if you can get the reference for us, at least we'll be able to look it up and know that we're looking at the right bit. Thank you. So, Winchester, page 190.
I just want to, before we move on from Winchester, I just want to make one observation about the I'm your man principle.
Yeah.
In each of the cases, I'm your man and Chuliak, where the permission was not effectively limited because there was no condition. In each of those cases, the thing which was sought to be limited, i.e. in I'm your man, the time period, and in Chuliak, the location, the precise location of the works of extension. In each of those cases, that was set out in the description of development. And this is an important point about the I'm your man principle, is that it does, to a certain extent, violate, or at least it sits alongside in a slightly uncomfortable way, with the notion that my Lord Justice Mayles put to me, namely that you simply read the document and see what it says. If you had simply read the document in I'm your man and seen what it said, you'd say, well, look, there's a time limit in the description of development for 7 years. Similarly, if you read the description of development in Anchuliak, you'd see there was a restriction as to, or there was an indication as to where the works of extension had to take place. But yet it was found that that was ineffective because of the absence of a condition. So whilst I fully accept my Lord's point that you look at the planning permission as a whole, you have to do so in my submission on the basis that there is a legal framework set by these cases as to how the permission is to be read and how it is to operate in law. And it's in that context, with that said, my Lord, that I'll turn to Winchester, which is page 197 or thereabouts of the authorities bundle.
Yes, in fact, in the new bundle, it's 198. Yeah.
And this goes back to the fundamental point I made at the beginning of these submissions, namely that this is a two-stage exercise. You identify whether the use is within the permitted use. and then if it's not, you identify whether there's been a material change of use. And what Winchester effectively said is that if you, the right way of using the I'm your man principle is that if there is a change of use, you don't then look to see whether there is a condition controlling or preventing that change of use. You look to see whether that change of use is material. It's in those cases where the essential permitted use of the land remains unchanged, but there is some change in the nature of the activity, but where that change of use in the nature of the activity is within the existing permitted use within the description of development, the essential land use permitted by the planning permission. If it is some subset of that use which is sought to be controlled, then that can only be done by condition. So in I'm your man, for example, the essential land use was the same, just took place over a longer period of time. So therefore that had to be controlled by condition. In at Tunya Kayak, the works of extension, the essential land use permitted, essential development permitted, was the same. And therefore it required a condition in order to control exactly where within the planning unit that work was done. And that's the distinction that Winchester draws out. What Winchester does, it takes, the court goes through a series of decisions in which the functional use was said to be described by the description of development.
Do you want to take us to the salient passages?
Yes.
Whether or not those are the ones that the inspector referred to. I think she actually quoted parts of the judgment.
She did, and I'll come back to that if I need to. It really starts at paragraph 21, my lords, page 204.
Yes.
Where Lord Justice Sullivan suggests that the I'm your man line of authorities has been misunderstood, and the unifying feature, I read from the bottom of paragraph 21.
Before we get there, just to understand what the case was about, I'm looking at 19.
Yeah.
The planning permission in the present case was for a change of use of agricultural land to travelling show people site. It permitted that change and no other.
Yeah.
It did not permit a change of use for the stationing of caravans for residential purposes.
Yes, and the debate in the case was effectively whether that description of travelling show people site was effectively what they were called a functional limitation, in the same way as had been identified in the earlier cases that were considered in Winchester.
Well, what Lord Justice Sullivan was doing, I apprehend, was focusing on the terms of the grant. What was this a planning permission for, was his focus, before coming on to the presence or absence of any particular condition.
That's right.
What was this a planning permission for? That's where one starts. Interpolating that, I think, sensible supposition from what actually Lord Justice Sullivan said. And as my Lord points out, paragraph 19 is to identify what the planning permission was actually for. Is that right?
Yes.
Yeah. Because it's that which is limited by a condition, or not limited by a condition.
Yes.
And looking at 20, it seems to be saying that a planning permission for travelling show people is different in character from one for residential caravans, because there are specific characteristics that have to be met if you're a travelling show person.
Yes.
Right. So the use is only for a travelling show person's site.
Yes. And what
The first question in our case would be, what is the planning permission?
Yes. Yes. What is the essential functional land use which is permitted by that permission? And
Well, is it the essential functional land use, or is it simply the development which is permitted? I mean, what is the development? If asked the question, what development was permitted here,
yes.
which might even a layman might ask that question, what was the planning permission for? A layman might ask. Answer: planning permission was granted for proposed site enhancement scheme, etc., as in the description of development on page 3 of the supplementary bundle. That would be the answer one would give, wouldn't it?
No.
No?
Well, not to say
What answer would you give to that question?
caravan site.
We're talking about the chalets.
A caravan
Well,
site.
It's not a caravan site, it's chalets and a caravan site.
The
It's not just for
yes, it is for a use of the land for caravans and for chalets. A number of chalets, yes.
but not, you say, the number and not the nature of the use that is being made of structure referred to.
No.
So, to be absolutely clear that I've recorded your submission correctly, if asked the question, what is this 1987 planning permission for, the proper answer is a caravan site.
A caravan site is with some chalets.
A caravan site with some chalets.
Yes.
Is it strange or not? This is an entirely neutral question, that the planning authority did not simply articulate the planning permission in those terms. It would have been so much simpler, wouldn't it?
It might have been simpler to do so, but the question is that the court has to discern now, as a matter of law, what's actually been permitted.
We know what's been permitted because that's in the description of development.
But the point is that if you had been asked as a layman to say, well, what was permitted by the I'm Your Man permission, you would say a change of use for 7 years.
Well, I mean, let's suppose that the layman knows what a residential caravan is, what a holiday chalet is, and what a static caravan is, and what a touring unit or caravan is. Let's assume that. Why would the answer not be, well, it's a proposed site enhancement scheme, etc., as described in the formal grant of permission? Why would that not be the answer you'd give the layman?
Because because the way that the permission is written necessarily includes elements which are defining the precise land use and ones which are not, and merely setting out numbers of a particular type of activity is not part of the essential land use which is permitted by that permission.
I think that's your key point, isn't it? Whatever the words used and how they'd be understood colloquially, what you're trying to find out is what is the land use that is permitted and what characteristics in that wording is inherent to the characteristics as compared to things that limit that land use. So the time, the number of units and so on are limitations, but not a description of characteristics.
Yes.
And that's what Mr. Purchase QC said in the paragraphs before the bit that you took us to.
That's right.
So we then have to ask the question, what is the land use characteristics? And if it's for mixed use, residential and holiday, aren't those land use characteristics is the next question.
Yes. Sorry, forgive me. Just repeat that last
You
part.
don't want to say yes to that.
No, that's why.
If you say yes to that, Mr.
We can go home.
Your case
Lapses.
is struggling.
Yes, I follow. Forgive me. Just I misheard, I think.
Well, I hope so. Couldn't you describe, or is the proper description one of mixed land uses, permanent accommodation or living accommodation, and non-permanent accommodation. It's a mixture of uses, mixture of land uses.
It is it's a mixed use in only insofar as there are permanent chalets.
Yeah.
Insofar as it contains a caravan element, the essential land use is merely as a caravan site. And the different subsets of caravans are merely limitations on the use, as your lordship put it to me, which would have to be secured by condition.
Presumably the logic of your submission is that, although in fact what your clients want to do is build a lot of, is install a lot of caravans, it would be equally open to them to more or less fill the site with holiday chalets. Under the current permission with no conditions.
It would, subject to the principle which I think learned from as the leader has mentioned, namely that if you have a mixed use, if one use completely extinguishes all the others within that mix.
Yes.
Well,
they have to keep some caravans, but subject to that, they could fill the place up with chalets under the, if you're right in your appeal.
Yes, that follows.
Yeah.
Yeah.
They couldn't
But
have.
again, this, forgive me, that goes back to the point that the purpose of a certificate is to certify that something is lawful, making no comment on whether anything else might be.
They couldn't just have structures on the site, I'm using the word neutrally, which were only for holidays, because it isn't part of the permission necessarily for residential use.
I think, disagree with that proposition.
Yes, because you say
to be logical,
it doesn't matter because
one must.
the description of 9 residential vans and 18 static vans and 13 touring units, all of the qualifying words, numbers and purpose are irrelevant. It's a van, a van, a van.
Yes.
And a van by any other name.
It is something which falls within the statutory definition of caravans.
So the only reason why this is a mixed use is because it's a van and a chalet.
Yes.
Yeah, that's the only mix or mixture that is identifiable and relevant is the mixture that distinguishes simply between a caravan and a chalet.
Yes.
And holiday must be the same then, so you could build dozens of chalets.
Yes.
Logically, on
subject
your
to the proviso I've just outlined.
which is what?
That if
well, a limitless number of chalets, as many as you could actually get onto the site physically,
yes,
would follow from your
would follow. Yes,
would follow from your argument.
Subject to the fact that there would have to be, or one would have to give consideration to the Whipperman principle, whereby if you've got a mixed use and one aspect of that mixed use, one component of that mixed use comes to predominate to the exclusion of all the other uses, then that can represent a change of use.
Well, what about 80 caravans for permanent residential use then? Solely and simply, which is the application here.
Well, that doesn't...
wouldn't that offend Whipperman on that understanding of Whipperman?
No, because the other use, the chalet use, is not excluded. All that is being sought to do is to certify the lawfulness of using the caravan element for one particular type of caravan.
Well, suppose the certificate had been for 150 chalets.
That would depend entirely upon whether it was possible within the site, given the other...
Well, suppose for the sake of argument, to test the point, which is my Lord's point, and I'm perhaps jumping in on his point, but just so to satisfy this doubt in my own mind. Assume for the sake of the question that you can demonstrate that you can physically get 150 chalets onto the land,
Yep.
the parts of the land that are flat enough to take them.
Yep.
Nothing said about caravans at all in the certificate application, but 150 chalets. On the logic of your argument, that would be a certificate that should be granted.
Provided that
Is that right?
provided that there was still capacity to
Well, that was the
accommodate
premise.
some caravans.
Oh, you'd have
Only one? Why
One.
more than one?
Why indeed?
so 150 chalets, and then either explicitly or demonstrably physically a single caravan. That would be a certificate that should be granted.
Yeah.
Should it? On your argument.
Looking at the words on page 3 of the supplementary bundle, which are descriptive words, which if they're to have legal force will have to be by way of condition. When I read it, I can cross out every word after the words to allow for, save for the word vans, comma, and chalets, because the 9, the residential, the 16, the holiday, the 18, the static, the and the 30, and the touring and the units are all descriptors. It's a chalet and van site.
Yes. Yes. And I make no apology
No, that's,
for making
no,
that
that's what you
submission.
say.
That,
That's
that
your
is
case,
the
actually.
effect of the authorities.
So it's a
and
mixed
the-
use, but only there's got to be something that looks like a chalet and something that looks like a van.
Well,
As long as you've got
that
one
is a
to
chalet
those.
and is a caravan rather than
Yeah.
looks like, but perhaps I'm moving that.
Yeah, but
But yes. Yes.
Yes. Well, perhaps we shouldn't think about the implications of that for caravan sites up and down the country.
Well,
I mean, I don't. We must focus on this case, of course. But anyway, we were about to look at paragraph 21 of Lord Justice Sullivan's judgment in Winchester. We'd looked at, with my Lord's help, at paragraphs 19 and 20. But you were going to take us first, I think, to paragraph 21.
I mean, yes, and I think the discussion with your lordship takes us, in a sense, probably beyond that. But
I mean, is there anything else you want to draw from Winchester?
only to look again, if I may, at paragraph 21
Yes.
and the beginning of 22.
Yeah.
where the I'm your man line of cases is deployed.
Yes, well, the first proposition is that the I'm your man line of authorities has been misunderstood by the appellants
Yes.
in that case.
And the basis of the misunderstanding is what is alluded to at paragraph 20, the beginning of paragraph 22,
Yeah.
where Lord Justice Sullivan observes that in none of these cases, i.e. in I'm your man cases, was there an alleged change of use from the permitted use to some other use.
Mhm.
And effectively, if there is a change of use, then the I'm your man principle doesn't apply. And one simply falls back on assessing the materiality of the change of use. Material change of use will not being necessary to require development, to bring about the requirement for planning permission. And so that's really the point to be drawn from Winchester. But it takes me right back to the beginning of my submissions, where the first part of the exercise is construing effectively the planning permission.
Yeah. So did you submit just now that I'm your man, or the I'm your man principle, does not apply to alleged changes of use, material changes of use?
If it be established that there is a change of use, i.e. what is permitted, what is occurring, does not fall within the description of development as properly understood on the basis of what is permitted and what is merely limitations which have to be imposed by a condition.
Yeah.
If there's a change of use beyond that, the mere fact that there isn't a condition prohibiting that change of use is nothing to the point. One jumps to the stage of assessing the materiality. What the I'm your man principle says Winchester is that if there is a difference in activity, but which is nevertheless within the confines of the existing planning permission, you can't prevent that change of activity without a condition.
But isn't this a change of use case?
No.
Because?
Because the planning permission, as I've submitted, is for, as we've established, a mixed use of chalets and caravans. And a certification that you can put residential caravans on this site, putting residential caravans on this site would be 4 square within the meaning of this planning permission.
Unless it requires a mixed holiday and permanent use, and unless those are genuinely land use characteristics.
Yes, precisely. Yes.
Perhaps I've not asked you the question precisely enough. If you look at paragraph 5 of the inspector's decision letter, page 219. Where she's introducing the main issues. She says, I shall approach this task by looking firstly at the status of the various planning permissions and their attached conditions. This will establish the existing lawful use of the appeal site. And then she says this, and enable an assessment of whether or not the proposed, and then she quotes the application for a certificate, stationing of up to 80 caravans for human habitation would fall within that existing lawful use. If it does not, it will then be necessary to determine whether the proposed use would constitute a material change of use from the existing, a change from the existing lawful use.
Yeah.
So she was focusing on those questions,
Yes.
appertaining to change of use and material change of use. That's what the case, she says, was about.
Yes.
Was
She's
she wrong?
No, she's set up precisely the 2-stage exercise,
And
which I say she has to perform.
And paragraph 5 is impeccable, is it?
Yes.
Yes.
Yeah. All right. So.
Where she's fallen into the error,
Mhm.
and where the learned judge falls into error by agreeing with her, is by accepting. Sorry, is by not accepting that the first part of that is made out effectively. That the certificate, the proposed stationing of up to 80 caravans, we said then and we submit now, falls within the description.
Well, then there are 2 points in the appeal. The first point, when it boils down to the essential issues, the first point is whether she's understood what the planning permission and its conditions mean, and that her conclusions you submit on that question were flawed, because she didn't understand that this was in fact a planning permission simply for a caravan site and chalets, and with some chalets. She didn't get that right.
Well, sorry, forgive me. Yeah.
Is that, well, I don't want to misunderstand what you're saying to us, but if you let me complete. The second question is whether she was entitled, if she was right on the first question, whether she was entitled to hold that it was, or conclude that it was a material change of use. That's to say, the description in the certificate would constitute such material change of use for the reason she gave. Those are the 2 essential issues, are they?
Yes, with 2 caveats.
Yeah.
The first being that the issue of whether or not proposed 80 caravans is part of the existing lawful use involves consideration of the permission and the conditions in the context of the I'm your man line of authorities.
Well, that's of course inherent in her in her analysis, if we go on, I mean, she grapples. You may say she got it wrong, but she grapples explicitly with the I'm your man line of authorities in paragraphs 36 through to 40 of the decision, wasn't she?
It's my fault, Mr. Vizier-Court, but I've now caught up with why you were so insistent on looking at paragraph 21 in the way that you're saying. Was Lord Justice Sullivan actually saying, I can't have regard to conditions when working out what the permission means? Or was he simply saying, on the facts of this case, I'm looking at the words show person's site, and I can see from that that there are certain characteristics which are not present in other kinds of sites, i.e. he didn't decide and didn't need to restrict himself from looking at the conditions because the meaning appeared sufficiently from the description, if you follow me.
Yes, to be fair, it's the latter formulation.
It's the latter formulation.
It is the latter formulation.
Yeah. So we don't know from Winchester that you can't look at the conditions to work out the purpose.
No.
No.
I mean, I'm not suggesting that.
No.
But I'm suggesting that there is a clear distinction between the essential use of the land.
Yes.
Those matters which are, as I put it, subsets of that use, which can only be controlled by condition, not by simple words in the
If you can't have separate land uses for holiday accommodation versus residential accommodation, then the fact that you've given permission for somebody to be present on the land is the end of it, really. Yeah.
Within that context.
Yeah.
Yes. And then, if I may, my lord, the second caveat I put on the matter is that if one concludes that there is no change of use, that's an end of the matter. And the issue of materiality of change doesn't come about because there is no change of use.
Well, if there's no change of use, there can't be a material change of use.
Yes.
I get that. Right, well, let's just take stock then. Do you want just to pause and reflect on where your argument is now? That's to say, where it is in its development in your submissions.
Yes.
What do you want to submit to us now?
I think I want to come on now to the approach that was adopted to those
by the inspector.
Propositions by the inspector and thereafter by the judge.
Yes.
I don't think I want to make any further submissions about the issue of essential land use. I think I've made my submissions that it is as a caravan site.
Yeah, you've answered our questions.
And I've dealt with that by question rather than
yes, but I mean,
submission perhaps.
you've made, in answering the questions, you've done so very clearly and fully. So my impression is that you've effectively made the submissions that you wanted to make on those questions.
Yes.
But if that's wrong, put me right, please.
No, I think anything else I want to say about those will come out of the treatment by the inspector and by the judge on those matters. If you fortunately just give me a moment to recover position within my notes. I'll go, if I may, to paragraph 47 of the inspector's decision letters, which is in the page 226
Thank you.
of the core bundle. I have it marked on my notes.
47. Yes.
And what she concludes there is that the A7 permission permits a caravan site at which caravans provide both permanent residential accommodation and holiday accommodation, and that the proposed use for the stationing of 80 caravans for the purposes of human habitation would be a change from this permitted use, in that it would encompass the use of any and all caravans on the site to provide permanent residential accommodation with no holiday use at all. And that's the sole basis, it appears, that she comes to her view. Now, Lord, there are two errors we say in that approach. The first is that she erects a distinction which in my submission does not exist between holiday caravan use and residential caravan use.
Could I
Which-
grant permission for a cottage for use for holidays, and it could only be used for holidays without a condition? So if I used it for something other than holidays, it would be out with the permission.
That would depend. It's a very I know it's a very unhelpful answer to this simple question. The question would be whether the use of the word holiday was regarded as a functional limitation within the meaning of the consideration that was given in Winchester. In Winchester, there were a series of cases in which different types of, one was a cattle depot, the travelling showman's site, where the use of the word cattle was said to be a functional limitation. The use of the word show people's site, i.e. caravans for show people only, was said to be functional limitations. And it would
Leaving
be
aside labels, which actually conceal the question and the answer, it's really two stages. As a matter of law, is it possible to grant a planning permission for use of a caravan for holidays, or use of a cottage or chalet for holidays, which would mean you couldn't use it for other purposes, things that weren't holidays? That's the first question. As a matter of law, is it possible to have that? Because then the second question is, did this permission do it or did it not?
Yes, we would submit that absent a condition, just purely on a description of development, that a holiday caravan is not a functional land use. So you would...
Yeah, forget the word functional.
All right.
That's just
In
the
those
argument.
circumstances-
It's not capable of being a definition of a land use.
Correct.
Is what you say.
That's my submission, Lord,
Yeah.
yes.
So if you say permanent versus non-permanent, which is the same thing, that's also not a definition of a land use.
No. In the same way, I would submit that a planning permission for use of certain buildings for 7 years is not a
Yeah.
limitation which is effective.
That's different, though. That says when the use must stop. This
Or
is-
indeed, or in the Antoniak case, where the precise indication of where works had to take place, where that limitation was incapable of being effective in law without condition.
So you can never, ever achieve a situation where a building is granted permission for use as a holiday cottage unless you also use a condition, put into the conditions, it cannot be used for purposes other than a holiday.
Yeah, that would be my
That's your
suggestion.
solution. Yep, that's fine.
Because the essential land use is the same. You're occupying a building for the purposes of living in it.
So your criticism of 47 is she's created a category of use, just a mixed category of use of permanent and holiday accommodation, and that doesn't exist because it's not capable of existing as a matter of law.
Yes, that's criticism number one.
Yeah.
In other words, a caravan is always only a caravan unless and until its use is limited by a planning condition.
Within a scheme of law, which I think is is clear, that you have the permitted uses, and if you want to control something which is part of those permitted uses, but may look superficially different, holiday as against permanent or whatever, there is a way of doing so. That control can be achieved.
Yeah.
It just has to be done by condition.
Well, it's traditionally done on, let's call them caravan sites. It's traditionally done on caravan sites by the use of a condition that prevents use or occupation for a particular period of the year.
Yeah.
If you break the year with a 4-month interval or longer over the winter, then traditionally it's been accepted that you're preventing the residential use of those caravans.
Yes.
And that's how it was done here, actually.
Well, but
In conditions,
it wasn't.
in conditions E and F. Well, perhaps I should say it is alleged that is.
That is indeed.
How it is. I should be careful to add those words.
Yes.
Because the other side firmly says that.
Yes.
So if I want to...
And the inspector, and the inspector accepted that, and so did the judge, actually.
Yes. That was the judge's only reason for going against effectively the line of submission I'm making.
I'm so sorry.
If I want to grant a planning permission for a holiday cottage,
Yes.
I built one in my back garden and I want to use it for a holiday cottage, I have to do two things. I may do two things. I will say permission for the application for holiday cottage is granted. I have a condition 1, this is to be used as a holiday cottage.
Yes, or in fact, you wouldn't have to go so far as the first step.
I don't need to describe it.
No, you just
Planning
say
permission is granted
permission
use
for
of
a
this
bungalow,
as a building,
permission for a building,
as a building where people can stay.
as a residential building, yes,
Yeah.
and then to be occupied by condition to be occupied only,
Residential, but only for holiday residents.
achieved as my lord said by a
You
temporal
can't do it that way.
restriction.
It just seems very odd that there is no category of non-permanent occupation or holiday occupation. No land use category.
Yeah, I mean,
you say no, it's not unusual at all.
forgive me?
And you say, but it's not unusual at all. That's the scheme.
That's the legislative scheme as explained by the case law. Now, there's no harm in describing something as a holiday cottage. It simply doesn't have legal effect absent a condition. And it's also important to remember that I don't want to be completely drawn into being definitive with respect to residential buildings. We're talking about caravans, which have a statutory definition, which my lords have seen. It's in the bundle. I can take.
When you're talking about chalets too, which are permanent structures, you can't say caravan. It's not a caravan site. You said it's a caravan and chalet site.
Yes, all of these submissions are based upon the premise that in order to maintain that mixed use, the chalets will remain. And that's not something which was traduced at all by the certificate. The certificate merely said that you could put 80 caravans on that land, permanent caravans on that land. It did not say you could put 80 caravans and nothing else on that land. It merely said you can put 80 caravans on that land and the chalets would remain, and the essential use would remain the same. That's how I put it. It is perhaps just worth noting the statutory definition of caravan. Your lordships would.
I think you want page 5 now, do you? Of the authority bundles. Caravan site means land on which a caravan is stationed.
Yes, it was actually more the definition of caravan, which I fear it's not made it into the bundle. It's somewhat later in the 1960 Act.
Right. Well, I think it would be helpful to have that.
yes, it clearly
So
would.
perhaps that could be brought after the short agenda.
Oddly enough, it says, I mean, I don't know whether you can read planning permission by reference to the Caravan Sites 1960 Act, but it defines a caravan site as a land on which a caravan is stationed for the purposes of human habitation. And that's what happened here, you see, even though it's not actually, the word caravan site is not used, you see, that's what it actually did. Well, a caravan and chalet site.
Yes, indeed. I mean, the essential framework is the caravan is simply a structure that's suitable for human habitation, which is capable of being moved.
And if you want to limit the periods or purpose, it must be by condition.
Indeed, yes. And then a caravan site, as your lordship has seen the definition, is simply a place where caravans are. And there's, I think it's the Wyre Forest Authority, which says that absent some reason for not doing so in context, you can read across the definition of caravan from the caravan sites legislation into the planning legislation. Now, my lords, I was examining paragraph 47 of the inspector's decision making, and I submitted that there were two errors. The first being this erection of a non-existent definition. The second being her misapprehension, as we would suggest it, that where one or other type of caravan use is permitted. Now, I say that's a legitimate exercise, an illegitimate exercise anyway.
Sorry, just repeat that. I'm sorry, I didn't grasp that as you said it. Just say it again, please.
Of course. Where there is effectively a specification of some units being for holiday use, some units being for permanent use, the inspector has taken, and I say that's an illegitimate exercise, but if there is such a distinction to be made, that the permission, you do not move beyond the bounds of the permission if you have all of the units being, in this case in residential use, to the exclusion of holiday use. Paragraph 47, what the inspector says, stationing of up to 80 caravans for the purposes of human habitation would be a change from this permitted use, in that it would encompass the use of all and any caravans on the site to provide permanent residential accommodation with no holiday use at all. And in my submission, given that that is not a change a la Whippemon from a composite use, chalets and caravans, it is merely a shifting of the actual deployment of the caravan part of the use. That is an inappropriate and an unlawful approach.
I'm sure I follow that. If your first submission is right, and that there is no valid distinction between holiday and residential, then that seems to follow.
Point doesn't arise.
But assuming that there is a valid distinction between holiday and residential, then is it not possible to read this permission, so far as caravans are concerned, as being for mixed holiday and residential use, so that to go 100% to one or the other would be a change?
Can I show your lordship, in answer to that question, a passage from an authority called Breckland, authority of Mrs. Justice Lamb, at page 143, or thereabouts of the authority's bundle.
Yes, I think it's 144. Breckland District Council.
Lord, yes. And the relevant, in fact, this is on the back of a certificate of lawfulness, but it matters not. The relevant certificate is set out in paragraph 6. Use of land as a caravan and camping site, including associated amenity area. And the submission was made effectively that you had to have a bit of both to be lawful, and that was dealt with at paragraph 39. Where her ladyship concludes. Claimant submitted that use as a camping site denoted temporary stays for holiday purposes, and therefore the meaning of the term caravan was qualified by the reference to a camping site limited to the same type of temporary use. I do not consider that's the ordinary and natural meaning of the words used. Where two alternatives are separated by the word and, the natural and ordinary meaning is one can do both or either. One alternative does not restrict the scope of the other. Example of a license to serve hot and cold food, which could be used alternative to serve any hot food or any cold food or both. Similarly here, the site could be used for caravans or tents or both.
But that can't be a prohibition that in every case where two different uses, assuming they are different uses, are referred to, thereafter, irrespective of all other considerations, it can be either or and doesn't have to be both. It must surely turn on the words of the planning permission read as a whole. And if in fact you were satisfied objectively that it really had to have an element of both, this judgment can't possibly mean you can't do that. This is just construing that permission.
It is, but it's making, in my submission, the point of language that if you're permitted to do two things, one and the other,
and there's nothing to indicate you have to do a bit of both.
And there's nothing to indicate you have to do a bit of both. And in my submission, there isn't in this.
But that's the question, whether, yes, if it does indicate that you've got to do a bit of both, there would be nothing wrong and nothing in this decision which stops us doing that. It may be an unusual position, and it may be that the starting point is where you can have apples and oranges. You can have all apples or all oranges or both. It doesn't mean to say that if you read the menu and it's clear that you have to have an apple course and an orange course, you must do a bit of both. It's a bad analogy.
No, it's a helpful analogy. It's about my level. So it works.
I didn't want to bring up food in this context, but I bring up being an unfortunate word.
Moving on.
Yeah, please.
Just to help all of us, we've got, as it luck would have it, in Mrs. Justice Lang's judgment at paragraphs 34 through to 37, the relevant statutory definitions haven't proved caravan and caravan site, unless they've been supplanted.
No, they are the current ones.
So that work has been done kindly for us by Mrs. Justice Lang.
I'm obliged. Yes, I was looking in my skeleton for it.
I think that's right, isn't it? So we've got those definitions provided there.
Yes, well, I mentioned the Wye Forest Authority, and there it is set out in paragraph 34.
You did, yes, you also mentioned that, that's quite right.
So,
and that was House of Lords, wasn't it?
Yes. Yes, it was.
All right, no, that's very helpful, thank you.
So, that is how the inspector dealt with it. And to deal with my Lord Justice Lewis's point, in my submission, there is nothing in the essential land use definition taken from the description of development that requires both, nor is there anything in the conditions that require both. So that's how the inspector dealt with matters. Perhaps I can then go to the meat of the judge's consideration of this matter.
Right.
And one can perhaps pick it up at paragraph 32, 31 in fact, perhaps. And there we see recognition in my submission that the inspector herself, on a number of occasions, referred to the use, as I showed you lordships in paragraph 47, as the site as a caravan site. And then mention was made, as I've submitted in this court, to the definition of caravan site and caravan, paragraph 32, and the wire forest principle 33.
I mean, it can be a caravan site as well as being subject to planning permission, which defines the development in a more precise and definite way, and there's no logical inconsistency. Between those two concepts, is there that it is, as it were, generically a caravan site, but the development actually is this, which falls within the overall generic description. That's perfectly. Is that not what the judge was saying?
Well,
in context, I should add.
I'm not sure it is, given the centrality of the issue of exactly what was meant by the description of development in the planning permission, and also, frankly, by the use of the way he then reasons the case afterwards. Because at paragraph 34, you'll see that a submission is recorded, which is identical really to my own this morning.
Yes, well, that was what was submitted by your predecessor.
That's right.
Mr. Mackenzie below.
That's right. But what in my submission is important is the way in which the judge deals with this. In that paragraph, at paragraph 37,
yes,
he accepts that absent the condition, the Mr. Mackenzie's submissions may have had some force, and I respectfully agree. They not only had force, they were right.
Yeah, but what follows is important as well.
Yeah, indeed. Now, the first point to identify is that this is the sole basis. The use of conditions E and F are the sole basis upon which the judge rejected the submissions made by my predecessor counsel. So then in my submission it turns to examine whether that reliance on conditions E and F was correct to defeat those submissions. And the question is, on its wording, properly and fairly read, does that condition A prohibit the use of the site for 80 residential caravans? That's the substantive issue. And echoing the point that my lords have identified, namely that there is a correlation between the descriptive parts of the description of development, if I can call it that, the 16 holiday chalets, 18 static vans, 30 touring units. Mirroring that, the condition only bites upon chalets, which we can disregard for these purposes, and then what it calls static holiday caravans and pitches for touring units. So it imposes an effective control on holiday caravans and pitches for touring units, but on its terms, read fairly, it does not exercise any control over residential units. And in my submission, whilst it's obviously right that one reads the condition together with the reasons for the condition, the reason for the condition cannot insert words into a condition which are just not there. And any reference to control of residential units is simply absent in my submission from the wording of that condition. And there's no proper legal basis for somehow trying to imply it because of the reason that's stated for the condition,
Well,
or indeed what the what the court might perceive to be the rationale that the local planning authority thought it had at the time. That's not the function of interpreting a condition. One simply has to look first and foremost at the words of that condition. And in my submission, they're plain, and my submission is made out that there's no control of residential caravans in that condition.
Yes, forgive me for...
Forgive me.
No, I simply wanted to ask you about something you just said, but it was right that you should complete the submission. I just want to test this with you, if you can help me. If it's right to read the condition together with the description of development,
Yes.
if it is, we know that I'm trying to be as neutral as I can in the way I formulate this. We know that the condition is directed specifically to chalets, static holiday caravans and pitches for touring units, and specifically those things. It's not, as you emphasise, directed to the residential vans.
No.
But if the real purpose of condition E is to prevent residential use, it wouldn't be, would it, directed to the residential caravans, because that would be a contradiction.
Well, with respect, my lord, it's difficult. It's difficult to carve from the stated words that the intention was to prevent, or not even to prevent, to limit the residential use. Residential use is already explicitly identified as one of the possible species of caravan use on this site.
Yeah.
Is it that hard if you look at the two reasons for the conditions, E and F? It's absolutely plain, isn't it?
Well, I must wish my lord no.
Right, well, if the whole site can be used for residential caravans, then how does that protect the character of the park during the winter? And how does it ensure that park remains available for use by touring caravans?
Because there's nothing at all to say that the pattern of use that accompanies a holiday use, the holiday paraphernalia and so forth, is different from that which is attached to a permanent residential use, where there's much more incentive to keep the sites tidy and the like. And therefore, you can't simply say, oh, well, because they're trying to protect the appearance of the park in winter, that is a prohibition of residential caravans. If that had been the intention, one has to say, why is it not set out in the condition?
Could I ask another basic planning question? Planning 101.
Oh, God.
Could you have a planning permission expressed in the following terms? Permission is granted for use of the site for the stationing of touring caravans.
If I can rephrase my lordship's question.
Rather you answered mine, but
Well, no, I mean in the
another
sense
if you
that
must.
I'll answer it directly. Yes, of course you could, but it wouldn't be effective in law.
No, because unless I also had a condition saying, and they may only be used for
Correct.
touring caravans,
That's right. That's right.
you've always got to do that.
Yes. Yes. I mean, what you couldn't do under such a permission is build a factory there.
No.
You know, because
The point is that you cannot. A caravan it really is a rose by any other name. A caravan is a caravan, and once the word caravan appears in the permission, it's for human habitation, and there can't be any restriction by trying to limit it to the description of the van, touring, or by limiting it to the purpose or the period. Any limitation, once you've granted permission for a caravan, that's it. It's a caravan. What happens inside and for how long it happens inside, if you're going to control it, it's got to be conditioned in your case. Yeah.
Yes.
Gosh, right.
I mean, what we
I
can...
don't find that a surprising proposition. You have a statutory definition of a caravan, which is a structure capable of human habitation. I'm paraphrasing. Capable of human habitation, which is capable of being moved. And the type of human habitation that goes on is irrelevant for the purposes of that statutory definition. That's what you're granting permission for, as part one of the exercise.
But you couldn't have a static caravan under the permission that I've described, permission to use the site for the stationing of a touring caravan. You'd allow me to have that if it was a static caravan and had no wheels and couldn't be moved. That would be all right.
No, a static caravan, forgive me, a static caravan does fall within the definition of caravan.
In my planning permission for use of the site for the stationing of a touring caravan, if it didn't have any wheels, it would be a breach, because it wouldn't be a touring caravan. It'd be a caravan.
Well, absent the condition, my lord, no, it wouldn't be a breach.
Right.
Because my submission is that the caravan is a caravan is a caravan, as the lordship puts it.
So the only thing that exists in the legal world of planning is a caravan. And there aren't any subdivisions that have a land use context.
Within the primary land use context,
It's a caravan.
that can be put into a description of development and survive and be effective
Yeah.
without the assistance of conditions.
Yeah.
And that's not a startling proposition, my lord, because the conditions regime is there. It's there for a purpose. It's there to control the primary use of the land. And if one wants to descend to the particulars of exactly how and when and whatever the caravan is to be used as such, you do it by condition.
Yeah.
And that follows clearly in my submission. The existence of that kind of concept follows from the I'm your man line of authorities. There's nothing weird about that because it's there in authority. And the exercise the court's engaged in is looking at the fair words of the permission in that legal framework. And you can't ignore that legal framework in my submission when construing the condition.
Right. So, where are we?
So I think really, my lords, I've made the submission's, I think, simple in terms of the language of that condition, the lack of effectiveness of it. And given that was the judge's only basis, conditions E and F, that was the only basis if one considers paragraphs 37 and 38, 39 of the judgment, for dismissing the submissions that Mr. Mackenzie made and as I've now effectively repeated to you.
Well, you say the judge was wrong in those paragraphs, which are the core paragraphs in his analysis, because he misunderstood this basic point about the effect of the absence of the condition.
Well, I think more that not so much he misunderstood the effect of the absence of the condition. He gave to a condition.
Well, he invested in the condition that was imposed a greater and more significant meaning than it can properly be construed to have.
Yes, I'm greater and more significant. He gave it a meaning to control residential.
Well, that's what I mean by significant.
That it simply can't bear. Yes.
It had that role.
Yes, I'm sorry. I've
No, that's really what I was getting.
distorted your lordship.
Not a bit. No, you put it more precisely. That's fine. So that's really.
So that really takes me, I think, to the end of my submissions on effectively my grounds 1 and 2. There's always a difficulty in this court that one pleads clearly defined grounds and then discussion tends to merge them together.
Well, to help you, if you remember earlier in the argument, I was asking you whether there were really 2 essential questions, which I think we isolated at that point. Do you remember that exchange? And to help you, I think your grounds 1, 2 and 3 may correlate to the first of the issues.
Precisely that.
And your ground 4 correlates to the second.
Yes. Now, my ground 4.
So we're going to ground 4.
We're moving on now. It seems to me I've encapsulated the argument with respect to that first part of the 2-part process.
Yes.
And unless your lordships want further elaboration.
Well, not for my part. It's what you've said is very clear. Thank you.
And then I move on, and I've already made the submission, which your lordship I think took as axiomatic, that if there is no change of use, then issues of materiality don't arise.
Yeah.
And I think the ground 4 submission can be put really quite shortly and simply.
Yeah.
The inspector concluded that notwithstanding the fact that the site remained a caravan site, that an increase in the number of caravans represented a material change of use. And she did so by reference to the statements of principle in the Hertfordshire case, which your lordships will see at page 208 or thereabouts.
Just a second.
Do the lordships have it?
Yes, yes, thank you.
Forgive me, sorry. The marked paragraphs for consideration, this was in the context of an industrial site, a scrap metal yard site. Paragraph 9 is where the helpful reasoning begins. Not disputed that an intensification of a use is capable of constituting a material change of use. And what's accepted by the parties is whether the test for deciding whether there's been a material change of use is whether there has been a change in the character of the use. And then at paragraph 11, the test applied by the inspector is endorsed by Lord Justice Bell in this judgment, resulting in such a change in the definable character of the use. And reference to Mr. Justice Ousley, as he then was, the need to identify a material change in the definable character of the use of the land. And what we say very simply is that given that the inspector had accepted, as she was right to, that the essential character of the use of the site was as a caravan park, it can't then be concluded that the definable character of the use has changed. All the essential elements of the use are the same. And the factors that the inspector identified in her decision letter about the distribution of the caravans across the site and so forth. All of those are simply manifestations of the same character of use as a caravan site. And therefore, her finding on material change of use can't stand. Now, my lords, I've obviously set out some supporting text in the skeleton argument, but really that's the essence of the submission.
Yes, it's a very simple submission.
It's a simple, I think, and I hope clear submission. I don't propose to say very much more about it.
No. Well, there's
I'm
for
sure
my
to
part,
say.
for my part, there's no need for you to do it because you've set it out very clearly. Of course, it's amplified in the skeleton argument, but I imagine that you will adopt the written submissions as your argument.
No, I don't wish to burden the court with any further listening to me.
Fine, it's very clear.
Can I just take a moment then to,
Of course, yes.
subject to your lordships, to take a moment just to see if there's anything else I've missed?
Of course, yes, please do, yes.
Those instructing you. Thank you, my lord. There's just a couple of short points which come from those instructing me, which are just useful to put forward. Simply, the first is simply a matter of an illustration of the importance of the variety of ways in which habitation can be established. The certificate, in fact, says 80 caravans for human habitation. That's what's sought. Now, the expectation, of course, is that they'd be permanent residential caravans, but they need not to be in those circumstances. And
Well, sorry, just to be clear, you began, and I noted when you did begin, right at the beginning, you said to us, you used the expression permanent residential use. That was your opening remark. In your
yes, I mean that is, I'm sure, what would take place.
Well, what is the case? To be clear, what is the case that is being advanced? Is it that it is permanent residential use, or that it doesn't need to be permanent residential use? It could be temporary use. Do you want to take instructions on that, because that may be quite important to those behind you, Mr. President?
Yeah, perhaps I shall.
Yes, I think it might be wise. Just if I may respectfully say so.
Yes, thank you, my lord.
Yes.
The situation is this. The application was for a certificate, as one sees from the formal parts of the decision letter,
Yeah.
for the stationing of up to 80 caravans for the purposes of human habitation.
Yeah.
Now, the case was presented, as I have this morning, on the basis that that would be effective to permit permanent residential occupation. And that would be the intention, certainly, I think, with respect to the overwhelming majority, if not all, of the caravans. But it would be perfectly possible for some of those to be in use as holiday, some or all. And if and those which were in use for holiday purposes would still be subject to condition E.
Yes.
So condition E would beat up, would as I've submitted, bites on those which are for holiday purposes.
But perhaps it doesn't matter because the certificate application said what it did, and that clearly would, on the construction you advanced earlier, include, though it need not, but it would include and it would extend to 80 caravans used in permanent residential occupation. It would include that, so it would make possible that, even if it would also make possible something less in terms of residential occupation
Yes.
and use.
Yes.
So you're not in any way, nor could you actually, alter the terms of the application.
No, or of any of my submissions I've made.
No. All right. So
In respect of
it's as much as 80, but it could be fewer
Yes.
in permanent residential use. Right.
Yes. And the other point, just to make by way of clarification, my lords pressed me on this issue of the continued existence of the chalets.
Yeah.
And the inspector in her decision letter at paragraph 60, page 229,
Yeah.
explicitly identifies the fact that her last sentence, put another way, the proposal for the stationing of up to 80 caravans on the planning unit could only be in addition to the existing chalets, not in place of them, and also some trees. And just finally, reverting back to the questions put to me by Lord Justice Lewis concerning a holiday cottage. I simply remind my lord that housing applications for planning permission for housing contain all sorts of different descriptions of the housing: executive housing, retirement housing, low cost housing, even, all of which have to be controlled by condition to be effective. And into that category, holiday would form no difference. So, my lords, unless I can assist further.
Can I just make sure I've understood your case about material change of use and what you say the inspector got wrong? You made your submission about that, but as I understand it, if we look at paragraph 50 of the decision letter on page 227, that's where the inspector sets out the test which she's going to apply. And as I understand you, she gets the test right in paragraph 50. You haven't criticised anything she's said there, but it's when she goes on to apply it that she gets it wrong for the reasons you've given.
Yes.
Is that your case?
That's my case.
Yeah, thank you.
We have no more questions for you. Thank you very much, Mr. Fraser-Rickett, for your very clear submission. Yes, Mr. Parkinson.
Thank you, my lord. Before turning to the various points raised, and in particular the two key issues as you formulated, my lord, I thought it'd be helpful to give our headline points to the appeal and each ground. And there are 5 key points, and overall we say that the appellant has overcomplicated what was an essentially straightforward decision here. the first point and the starting point, as both the inspector and the judge recognised, was to determine the scope and true nature of the 1987 permission. And that's, my Lord, Lord Lindblom, your first essential issue. And we say that both the inspector and the judge were correct to conclude that permission permitted a caravan site at which caravans provide both permanent residential accommodation and holiday accommodation, the year-round use of the latter being prevented by condition. I'll obviously come on to the permission and its conditions in more detail in a minute, but we say respectfully that conclusion was obvious, since 30 of the caravans permitted by the permission, that's the touring units, could not be used for 4 months of the year. That's condition E. And each touring caravan could only be on the site for 3 weeks at a time. And as was common ground at the inquiry, those 30 touring pitches could therefore not be used by someone occupying a touring caravan as their permanent residence. So you have a permission for 57 caravans, 30 of which, if you read the conditions together with the description, as we must, cannot be used by someone as their permanent residence. So this is clearly a mixed-use permission. That's the starting point, and that's my sort of headline point 1. Second point is you then look at what was sought by the certificate. As we know, that's to certify as lawful the use of the land for the stationing of up to 80 caravans for the purposes of human habitation. Now that would have certified, on the exchanges at the end, that would have certified a whole range of potential uses as being lawful. It would have certified 80 caravans in holiday use, 80 caravans in permanent residential use, and every conceivable combination in between. But both the inspector and the judge were entitled to focus on the lawfulness of 80 caravans in permanent residential use. Not only was that the focus of the appellant's case before the inspector, but if that particular use wasn't lawful, it didn't matter if some other combination of caravans in permanent residential use or holiday use, or indeed different numbers, would be. That's the second point.
Yeah, just if you could, do you mind just slowing down very
Of course,
slightly,
sorry,
because
yeah.
I'm seeking to get a note, and it's just about possible, but it's a little uncomfortable at your present pace. Thank you. Sorry to interrupt you.
No, of course. Then the third point is the inspector recognised that proposed use, so i.e. 80 caravans, all in permanent residential use, was not unlawful on the basis that it amounted to a breach of any condition. Actually said in terms, there's no condition limiting the number or type of caravans that may be present. However, she correctly identified that proposed use could nonetheless be unlawful if it fell outside the scope of the 87 planning permission and also amounted to a material change of use. And I do draw that slight distinction between falling outside the scope as the first question and then it being a material change of use as the second question. And that demonstrated a correct understanding of the Iron Land case law. And I'll go through that, but I intend to focus on the statutory wording because the I'm your man case law, can I respectfully submit, be more easily understood by reference to the statute, and ultimately planning is a creature of statute. So that's my third point. The fourth point is, it is, again, respectfully, we say obvious, that a proposed use for 80 caravans, all in permanent residential use, doesn't fall within the scope of the permission for 57 caravans, 30 of which cannot be used by virtue of conditions E and F. Permanent residential use. Falls outside the scope. So you then move on to my fifth point, and the second essential issue or main issue in this case was it's a material change, and asked, if it's not permitted by the 87th permission, is it a material change of use? And the inspector asked the right question, reached a whole series of planning judgments, and concluded that it was. And picking up on some of the exchanges from this morning, it is perfectly possible, both in the caravan context and more widely, to have two uses that fall within a generic descriptor that are of materially different character. And the classic example would be holiday lettings and use as a dwelling house are both residential uses. But going from use as a dwelling house to use as holiday lettings can be, it's a question of fact and degree, can be a material change of use. And that's established by this court in the Moore case, which I'll come to at the end. So there's nothing unusual, surprising or difficult about saying these are two uses with different characters, but generically could be described as falling within the same generic description. Those are the 5 main points that I'll now develop. And I'll start off obviously with the 1987 permission. So page 3 of the supplementary bundle. And the first point I would obviously make is that this is a permission that describes with precision the number and type of units permission to be stationed on the site. 9 residential vans, 16 holiday chalets, 80 static vans and 30 touring units. And that's what was permitted. And that's what a reasonable reader of the permission would understand to have been permitted. I'll come on to Trump in a minute and what that says about how you interpret permissions and the relevance of conditions. But that's what a reasonable reader would say permission to be granted for. They wouldn't say permission had been granted for a caravan site, because the writer of this permission has gone to the trouble of then specifying the number and type of the individual caravans permitted. That's the first reason why someone would not look at this and say, oh, this is permission for a caravan site and some chalets. The second reason is, and I'll obviously develop this in more detail, the effect of conditions E and F. Because if we read conditions E and F with the description as we must, it is clear that not all of these 57 caravans permitted were intended to be used for residential purposes. So it may be helpful to go to Trump on how to interpret permissions and the relevance of conditions. It's in the authorities bundle at page 123. And it's the often quoted paragraph from Lord Hodgett, paragraph 30.
Is this not reported? A lot of the judges we've got, you'd expect to be reported. You're supposed to have the official reports because you have a head note. And law isn't just about taking a sentence out of context and say, look, that says apple pie is good and I like apple pie, therefore I must win. It's what was the facts, what was the ratio, and it's very difficult. And this happens day in, day out now. Is this just not reported?
It is reported, and you should have the reported version.
Yeah.
I apologise. No, I apologise about that. You should have all of the. You should have the reported version.
Do you know where it is reported? Don't worry if you
Not
don't, but we will have to find it.
Over lunch, for any of the authorities that I'm referring you to, that you don't have reported versions, so I can print them off at chambers and bring them back so that we've got the reported version.
If we have the references.
Yeah, I think actually if you just give us the references, then at least our labours outside the hearing will be reduced a little.
Because if it's an appeal case, it'll have the argument. Sometimes you have arguments about whether it's fair repudium or not, and you need to know what was cited. There is a reason, you know, it's not just a rule for the sake of it. Most rules have reasons. Somebody doesn't just sit there and think, what can I do to make life difficult? They think, what can I do to make the system work? But anyway, you know that, and you've said you're sorry.
My Lord, if I could just perhaps assist by interrupting at this point. I happen to have Lambeth in front of me as I was searching for my reference, and coincidentally it has the reported reference for Trump,
Oh, right.
which is 2016 1 Weekly Law Reports 85.
Thank you.
My Lord, if it's this, I can place paragraph 34 in a bit more context. That would help in terms of what the case was about. So we probably easier to start off with paragraph 1.
Right.
There's an application by Trump International Golf Club Scotland Limited for consent under Section 36 of the Electricity Act, which was then granted. There were then two grounds on which Trump International challenged the consent, and ground summarised in paragraph 2.2 was that because condition 14 of the consent, which requires the submission and approval of a design statement, is void for uncertainty. There was also a ground about whether there was power to grant under the 1989 Act. Ground two starts at paragraph 22 on bundle page 119, which sets out condition 14, which was alleged was void for uncertainty. And we can see the submission that was made at paragraph 23 submitted that section 36 consent is invalid because condition 14 is both unenforceable and also so uncertain that it was irrational. And that argument was rejected, and we've dealt with in the passages over the next few pages. But then if we turn to paragraph 31, there had been an argument made that even though the wording of the condition didn't require construction in accordance with the design statement, that should be implied into the condition. So it's dealing with the question of whether you can apply terms into a planning condition. And then what follows is a series of passages dealing with the approach to interpreting documents in the public law context. So we have paragraph 33. This is probably the starting point. Second sentence. The first question, therefore, is how to interpret the express words, in this case, in section 36 consent. And then refers to the modern tendency to break down approach to interpretation between public and private documents. And then we come to the passage, my lord, that I first took you to, paragraph 34, which deals with the interpretation of public documents. Now, in this case, it's a section 36 consent, but that would also apply to the planning permission. So the well-established test, you ask yourself what a reasonable reader would understand the words to mean when reading the condition in the context of the other conditions and of the consent as a whole. It's an objective exercise in which the court will have regard to the natural and ordinary meaning of the relevant words, the overall purpose of the consent, any other conditions which cast light on the purpose of the relevant words, and common sense. So this isn't a question of reading the description of development in isolation. The description of development plainly has to be read and interpreted in light of the conditions. And in particular, the reference to 30 touring units here has to be read, interpreted and understood in the light of conditions E and F. And condition E states that those touring units cannot be occupied all months of the year. And that is a well-established method for preventing use of a building or structure as a permanent residence, because if someone has to completely leave the property for 4 months in the year and move someone else, it can't be said that they're occupying that property as their sole or principal residence. And that's the effect of condition E. And we can see a similar approach being taken in the 2013 permission over the page on page 5. Now, I recognise that there's an unresolved issue about whether this permission has been interpreted or not.
Implemented.
Implemented or not. But regardless of whether it has, I would submit it can still be used to interpret what was meant by condition E on the 1987 permission, because it's a subsequent permission granted by the same planning authority, obviously, that in effect seeks to vary that condition.
Was it in fact granted by the same authority? The original grant.
No, it wasn't. No.
I mean, it's not necessary to your submission to make that point. I just wonder whether, more fundamentally, you can use one planning permission to construe another. Anyway, that's another point.
And a later one by a different body to construe an earlier one.
What you are entitled to say, to cut through this perhaps, is that it's clearly a document before the court, and you may submit that it demonstrates a particular approach. You may then submit that it demonstrates a parallel or analogous approach to the 1987 permission. But I just wonder whether you can go any further than that, that's all.
No, I suspect I hadn't appreciated the difference in authorities.
One was the county council and the other was the National Park Authority.
Yeah, I can't go as far as I was trying to go. What I can do, though, is it's evidence before the court that this is an approach that is taken by local planning authorities to seeking to avoid permanent residential occupation increase. And we can see that from condition 2 of this permission.
You want us to get that out? Yeah.
Yes, so it's page 5, chapter 2 of the supplementary document.
Yeah.
So it, in effect, amends condition E to reduce the period of non-occupancy to just 1 month February each year.
That can't apply to the residential ones, can it? Any caravan. It doesn't apply to the 9.
Is this, I wonder, where the difference in land areas becomes relevant?
Oh, the application
It
size.
is. I was trying to steer clear of that, only because...
Well, no, I just you don't have to go anywhere near it except to acknowledge that this was a different application site.
It's a different red line, yes.
Yeah. So it might still make sense, in notwithstanding my lord's correct observation, if I may say so, about any caravan.
So any caravan would be any caravan.
But it says any caravan within the application site.
And the application site is only has a different red line to the 87 permission.
So the residential ones are outside the application site.
And as it happens on the ground at the moment, the residential caravans are outside the red line of the 2013 permission.
So it does actually make sense.
So it does all hang together.
But in any event, it's expressly a variation of condition E of the previous permission.
Yeah.
So to that extent, you can read the two together.
Yeah, and you would read the two together. But it's the second.
Indeed, I think you must read the two together.
You would have
Yes,
to.
it doesn't make sense otherwise.
I think you have to, don't you?
You have to.
It's not an optional variation, is it?
Optional variation.
Well, in the sense that it may have been suggested, I think, elsewhere that one could pick and choose, as it were. This does have the effect of varying condition E on the 1987 planning permission. So we do have to look at this document.
If it was implemented. If the 2013
Yes, but it was assumed by the inspector. Well, I'm not sure she did make the assumption that it had been implemented. She was invited, I think, by the appellant actually to look at it.
Yeah.
But the point is that any caravan in 2013 means any of the static caravans referred to in condition E of 1987.
Yeah. Well, look, just for your note on what she said and where she said it, is paragraph 27 on page 222. And then over the page on 223, the key bit, 5 lines up from the bottom, which it says there's no conclusive information as to whether or not the 2013 permission was implemented or not. But since the appellant's evidence is it would need to be taken into account in assessing the materiality of any change, I'll proceed on the basis of being implemented.
That's right.
That's the way she wrote it. But the only reason I really take your lordships to it is the purpose, stated purpose behind condition 2 on page 6. To prevent the creation of unjustified permanent residential accommodation in accordance with various policies. So, having a period of non-occupancy is a well-established, I would submit, way of avoiding permanent residential occupation. But of course, in respect of the touring caravans, there's a belt and braces approach taken because we also have condition F. And condition F prevents a touring unit being stationed on the site for more than 3 weeks in each year. So, read together, conditions E and F, the practical effect of them is it would be impossible for somebody to occupy one of the touring pitches in a caravan as their permanent home. Because you can't occupy the pitches at all for 4 months in the year. But even in the remaining 8 months, a touring caravan can only be on site for a maximum 3 weeks at a time.
Well, the other thing about that as well, it's not just the occupancy. There may be 2 restrictions. One may go to the nature of the occupancy, permanent or non-permanent, holiday or permanent, holiday or residential. But the other thing is they're different things. The one are things that are there and are stationary there. The other thing is to allow things to come on and not to come on. And this appears to require at least part of it, or the contemplation was that part of it wouldn't be used for constant settlement, but would be used for coming and going.
Yeah.
So it can be described in a different way, actually. It's a mixed use site. On the left hand, you've got a housing estate. On the right hand, you've got a in and out touring place.
Yeah,
Those aren't the right words, but you can see the concept I'm trying to get at.
Yeah. And it wouldn't it's easy to slip into permanent residential or holiday, but of course there are other potential uses to which that they could be put. But
But the point
My
here
lord,
is
just
that it's not just a caravan is a caravan's a caravan. There's sites for the placement of non-mobile structures, and there's sites for the use for mobile structures. And your argument would be, I imagine, that you've got to have both, and that's a different, more convoluted way of saying permanent and non-permanent.
Yes, it's permanent and non-permanent.
It's got to be static and mobile,
Yeah, and
or at least an element, you say, of static and mobile.
yes, and when I come on to the second issue, I'm going to go through the inspector's findings, because she says that those different characters, so permanent residence and holiday, but also permanent and mobile, give rise to very different land use characteristics. And that's essential to understanding this permission, because the permission wanted both, or didn't want too much of one and not enough of the other. And we can see that from the reason behind condition F. To ensure that part of the site remains available for use by touring caravans. So one only needs to look at that to see that it's clear that this is a permission that is not envisaging that all of these caravans would be occupied by, my lord, as you say, permanent and fixed caravans that are being used as someone's permanent residence. And yes, there is no condition that says you cannot use the touring caravans as your permanent residence, but you can achieve the same purpose by conditions E and F. You can enforce conditions E and F, they're straightforwardly enforceable, and actually not having a condition expressed in a way that would say you cannot use touring caravans as your permanent residence. That sort of condition actually poses its own difficulties, because then you get into subjective debates about, well, when is occupation permanent or not, and when is it your residence? Actually, through this indirect route of having the 4-month period with no occupancy and the 3-week maximum stay, you achieve the same effect in a way that's easier to enforce. So that's the touring caravans. Can I deal then with the static caravans? And the same argument applies in relation to condition E. And in addition, one actually doesn't need the conditions, because there's a distinction in the wording of the grant between 9 residential vans and 18 static vans, which could suggest that the 18 static vans weren't residential. I do have to be careful here, though. I want to take, in the complete interest of fairness, I want to take you to a couple of passages in the inspector's decision to see how she dealt with the static vans. Because she took a different approach, and it's important the court sees how she dealt with it. So it's paragraph 35 of the decision, from page 224. And I'll let Laura read that paragraph in full.
Did you say 35?
Paragraph 35, yes.
Thank you.
Mr. Isa was the planning witness for the appellant.
The appellant, yeah. And then Mr. Avens for the council. And I also then have to take you, once you've read that, to paragraph 52 later on. At 52. So tempting as it would be, I wouldn't want to pounce on any suggestion that the static inspector found that static caravans could only be used for holiday purposes and as a holiday use, because she didn't. And the way it was put to the judge below, it's on Judge Jarman, was solely in relation to the touring caravans. And
Yes, well, we noticed that condition E is for 3 types of accommodation, whereas condition F is very deliberately for only one of those 3.
yeah,
It is not, condition F does not limit the rotation, if you like, of occupation of the static caravans,
yeah.
only of the pitches for touring units.
So I think the way the inspectors approached this is where E refers to static holiday caravans.
Yeah.
That means that a static caravan in holiday use cannot be
Yeah.
occupied during the 4 months.
Well, you can keep your holiday caravan there for those months. Well, for those, you can occupy it for the months identified. But it can stay on the site.
It can stay on the site because the condition only relates to occupation.
It can stay on the site because it relates only to occupation. It's not a condition such as F. I mean, E and F are doing different things, as my lord has pointed out.
You know, if it's in
So if I own a holiday caravan, I can put it on the site for the whole year, keep it there, but only go there to use it for my holidays, which would be in the months permitted under condition E.
but certainly the
Whereas
way,
if I've got a caravan that I hitch up to the back of my car, go on holidays with my caravan, I can go to the site and have a 3-week holiday there, but then I've got to move on.
then you've got to move on. But certainly the way I put it below, and how I read the inspector's decision, is that in terms of the static caravans, condition E relates to static caravans in holiday use, but doesn't bite on static caravans used as someone's permanent residence. And that's how I put it below. And the reason why it doesn't matter is because of the 30 touring caravans. And it doesn't really matter what the position is with static caravans, because where you have permission for 57 caravans, the majority of them are touring units. So that debate about how you interpret condition E, which ultimately is a matter of law for the court, and you're not bound by the inspector. But she approached this simply on the basis of the touring caravans. So we have 57 caravans here, 30 of them are touring caravans. E and F mean you cannot use those as your permanent residence. So this is a permission for both caravans for permanent residential use and holiday use.
I tried to use the conditions to understand what the permissions are about.
Yeah.
One reading is they put the word holiday in. They're clearly not referring to the 9 residential units. They're talking about the 18 static vans.
Yeah.
And they put the word holiday in because that's the consequence of the condition. So it does cover all 18 on one analysis, but you're saying no, that the subdivision occurs earlier, and once it's residential, you can use it year round.
I wouldn't want to submit that what my lord's put to me is the wrong interpretation, simply to note that the inspector hasn't
Took a different one.
gone that far.
Yeah.
And because you didn't need to go
Yeah.
that far. Because even with the touring caravans and conditions E and F on the touring
But we
caravans,
shouldn't say anything because it might be very relevant to somebody who's got a static caravan that they want to live in all the year round.
it could be, yeah. I mean, ultimately, the interpretation is a matter of law, and no one's bound by what the inspector found.
Well,
I just wanted to
she
know-
dismissed the appeal, so there is no certificate.
Yeah.
So the position, the planning status of the site is to be gleaned from these 2 planning commissions. Correct? Yeah. That's where we are now. It's not as if she granted a certificate in certain terms. She didn't grant a certificate. There is no certificate.
But I just wanted to draw that to the court's attention, just to clarify the basis that she found. This was a mixed use, to use the short term.
Yeah. And this is reading the conditions, particularly E and F, of course, with the description of development and noticing the interconnection between the 2.
noticing the interconnection between the two, as Trump says that we should. Noting the reasons behind those conditions. And noting that the effect of enforcing those conditions is that 30 of the 57 caravans permitted could not be used as someone's permanent residence. And then after lunch, I will be submitting that, if you're with me on that, everything else is completely straightforward. Because we've got permission for 57 caravans, 27 could be used for residential, either holiday or as your permanent residence, 30 of which can only be used for holiday. And you have an application for 80, all to be used as someone's permanent residence. And you ask yourself, does the 80 fall within the scope of this permission? No. Is it material change of use? Yes, because you can have a material change even if generically this is a caravan site. But if now's a suitable point, I can develop that after lunch.
Yeah. Right, we'll come back at 2:05. Thank you very much. And after the adjournment, it would help us to have the references for the law report references for the authorities relied on by all three advocates, and also to have a print, it would help us, of the Lambeth case, please. Thank you very much. Then 2:05.